interested in. We didn't have any real legal analysis and writing program. We had 1 or 2 lectures given in the moot courtroom by a second-year student, I think, from the moot court board on how to blue book, how to do legal research. And then we had mandatory first-year moot court, but it was run by the students, the moot court board. We were in the same small section. You had 125 in our big sections, and then we each were in one small section. We were in criminal law. And Joan and our friend David Poe were partners, and I and a guy named Larry Skoglin were opponents. When the moot court board told us how to dress
this is
for the oral argument, we were told to wear coats and ties. They forgot that they had some women. So I borrowed a coat and a tie.
So did I.
And Joan borrowed a coat and tie. And I wore a coat and tie to argue, and like over my mini skirt, which I'm sure was quite the outfit.
I wore it, but showing
better judgment, Joan.
I left my coat actually on the chair, so I argued without it. And it is so funny after we argued, and again, supposedly we did a fairly good job, but the professor
was David Lang,
who's still here, but he said, you did such an excellent job. It was better than most of the arguments I saw in the Illinois Supreme Court, and I was so pumped when I heard that. Wow, this must be really something, Illinois Supreme Court. And then my practice kept me in the North Carolina Supreme Court most of the time, and I thought, well, this was nothing.
You're right, when you realize.
This was faint praise.